Hey guys, this is Karalynn, and welcome back to the podcast where we talk about all things construction and legal. Today, I want to take some time to talk about how to prevent disputes, and if you can't, what the litigation process looks like, right? Nobody ever wants to go to litigation. It's expensive, it's time-consuming, it's stressful, but eventually, as a business owner, sooner or later, you're going to have a litigation case. And I want to kind of give you a roadmap of what that looks like. First, let's talk about how to prevent disputes, right? And so I like to break this down into the two different types of contractors that we deal with, residential contractors and commercial. So let's start with commercial contractors. So commercial contractors, subcontractors, usually disputes arise throughout the project based on multiple factors. You're not performing as fast as you could, if as fast as required. There's an argument about whether work that was included in the scope of work is included in the scope of work or if it's extra. The main thing that you want to think about is you want to think about what will I need and what will be the next steps if this dispute doesn't resolve, right? And so I'm going to tell you, like, if I was walking to the courtroom with a perfect client, what would I want from them if we're in a dispute? The best thing that you can do is if you get an email or some type of notification that there's a dispute, you need to respond timely to that with another email or some kind of follow-up. Because although it's just an email, under the contract, it could still be considered a notice of default, right? And all of those notices of default can lead up to them terminating your contract or, ending the relationship. And what you want to have is a timeline of events, how they occurred, right? So if you get that email, if you get that notice letter, you can say, no, I disagree. Here's all the guys we've had at the job and every day, and here's their hours that they worked. Really telling the full story as the time it happens. You know, if we come to an arbitration or litigation, we have this stack of emails that the other side sent saying, I told you this time, and we don't have any responses. It's kind of, oh, I guess they were right because you didn't respond. Right. So even the smallest things, you don't have guys out there, we're going to supplement your work. All of that needs to be responded to. And is this work a change order? Is it included in the extra scope? In commercial contracts, you really don't have the option to stop working. So the best you can do is document how it's outside of your scope of work thoroughly with a change order request or in emails. If they decide that, it's in the scope of work and they're not going to pay you, you could always file a lien to be paid. But the main thing is to document it, address the situation. If it's something that you did wrong that needs to be corrected, jump in, address it. Don't let the general contractor just handle it or give you a deductive change order. So the main thing is to have a clear paper trail of here's where the things that we got off course on, here's how we corrected them, or here's how we weren't off course. Here's how, here's all of our proof, all of our evidence. That's what you're going to need. And so you need to come at these disputes thinking the longer term effects, that if I was in a courtroom or in front of an arbitrator, what would I want to show them to tell them my side of the story, right? And that's kind of what you want to do throughout, even with the smallest email or text. Take the time to thoroughly respond. And so for my residential clients, same thing, right? We get into mishaps with clients all the time, the things that weren't done right or they weren't happy. So if it's done verbally and they say, hey, we're not happy with this, have the meeting, figure out how we can correct it, or if we can, and then follow it up with an email. Today we had a discussion, you weren't happy with this, here's how we're going to correct it, or here's how this is not my scope of work and I'm not going to correct it, right? Just having those very detailed emails, text, whatever, something in writing to prove your side of the story and what happened. It is priceless later on, right? And just keeping that with your file and documenting it, right? And so for residential contractors, the litigation process works a little differently in most states. Most states have a process where the owner must notify the contractor of what's wrong, give a very specific detailed list. The residential contractor gets a chance to go inspect and then make an offer. And this process has to happen before a homeowner can sue a residential client, right? And if it doesn't, you can stop the lawsuit if they've sued you to make this process happen. In Texas, it's called RECLA. It's called different things in different states, but the process is basically the same. They have to give you very detailed notice. You have a chance to respond and then make a settlement offer. And if they don't accept the settlement offer, and they move forward with suing you, it could limit their damages later down the line. But the thing about that process, and whether it's a commercial dispute or a residential dispute, if you get that demand letter from an attorney, that's the point where you'd be like, okay, first off, don't freak out. Second off, don't ignore it. The first thing you do is go ahead, pull your file together, get all the documents. What I recommend to my clients is right at that point in moment, if you haven't already, write out a timeline of events as you remember them, whatever that is. Kind of look at the file, any pictures that you have, and just go through the timeline of events, because you have no idea how fast your memory can fade, especially if it's, a file that's, a product that you work on like 6 months ago. So, just go through and document everything you remember and the dates if you can, and the timeline of events and how they occurred. That's extremely helpful when building the case to defend you if you get sued. And that's on both residential and commercial. You get the demand letter, you do the timeline, you bring all of your information to your construction attorney and say, what do we do? Okay. And so usually what we'll do is we'll go through, we'll draft a response with all of your evidence and make some kind of settlement offer. And at this point, guys, don't get hung up on being right. You're going to pay more than you want to pay at that settlement offer. But trust me, it will save you so much time, heartache in the long run. You're going to be pissed and you're going to hate it. But trust me, paying them $10,000 now as opposed to paying $50,000, $60,000 for litigation will save you time and money. And so don't get mad at your construction attorney if that's what they recommend, even though you don't feel like you should. I agree with you. You probably shouldn't. But here's why you should. It's because you don't want to spend the next year of your life bogged down in depositions, discovery, being nervous about the outcome of this case until it's over, right? So really respond, take it seriously, even if you think it's bullshit, because most of the time it is bullshit, but less bullshit up front it will save you time and energy. I have a whole series on how litigation sucks. It does suck. It's expensive, time consuming, and stressful. So you do your best, you make a genuine offer. Not only could that help end it, but it could help show in the long run that you were truly trying to make these people happy and giving them what they wanted, or at least a part of what they wanted. So that the demand letter is usually what happens first. We go through some responses. If they accept the offer, we'll do some settlement docs and it's done. If they don't, then they might sue you, or you might sue somebody for money you're owed or anything like that. And so I kind of want to just walk through what the litigation process looks like. We have a litigation roadmap that we've created at the firm to help walk clients through the process so they know what's coming. They know what to expect. They know the next steps and where we're headed, and understand the work that we're doing and why that we're doing it, right? So we went through the demand letter. So at this stage, the next step is the lawsuit is filed, right? So they file it with the clerk or the district clerk. Listed in the lawsuit contains basically the facts and the legal causes of action that you're going to sue somebody for. So like in a residential or commercial construction case, they can sue you for breach of contract based on defective work. You could sue somebody to enforce the lien or breach of contract if you didn't get paid. So the lawsuit, the petition, the statement of claims, it's called something different in every state possibly, but it's what's filed with the court. And so once it's filed, the clerk accepts it and they issued what's called a citation, something that is a record of you personally being served with the lawsuit. So a lawsuit needs to be personally served on you. Okay. And so this is where it's important that anywhere you're registered, like if you're a company, an LLC, an Inc., and you're registered with the state, making sure that your address of where you're actually at is up to date. Because here's what happens is they'll go to that address that's listed on the Secretary of State or whatever, wherever you're registered with, and attempt to serve you, right, personally. If you're not there, or if it's a bad address or whatever, they could still, because you have it listed as the address for you on the Secretary of State, do what's called a substitute service and then mail it certified mail to that address. And whether you get it or not, you will be considered served. And if you don't answer, you can get a default judgment taken against you. So don't avoid legal papers. Make sure that your registered address is up to date. So when it's sent somewhere, you'll actually get it, right? So if somebody's trying to come and serve you with papers, accept them. Once you accept them, don't ignore it. Because what can happen is, so you're served with the lawsuit, or you serve somebody with the lawsuit, they have a time frame in which to respond. Normally to 20, 30 days, they have to have a written response in court to the lawsuit. If you don't respond, you lose by default. Meaning if somebody sues you, you get the papers, or they say you get the papers, they can take against you what's called a default judgment, meaning they win by default. They say what happened, they verify the amount that they're owed, and then the judge signs a judgment saying, okay, nobody appeared, so I agree with you. And now there's a judgment against you and or your company. So don't ignore it. That's the worst thing you could possibly do. You need to file an answer. It's anybody can sue anybody for anything. Just because they say it doesn't mean it's true. But if you don't respond, the court will take it as true. So if somebody doesn't answer, the court will take a default judgment, and then you can go about trying to collect the judgment, whether that's selling the property because you got a default judgment on your lien foreclosure, garnishing people's bank accounts, their assets. All that's up for grabs if you don't answer a lawsuit. So but in a case where we're suing somebody and the defendant, so we're saying we're suing to enforce a lien and on breach of contract, and the defendant files an answer to the lawsuit in court. Okay, so what we're going to do is we're going to kind of go through your case, see what we have. We're going to make what's called a case strategy outline. And what that is like all of the elements you would need to prove in court, we break down into an outline, and then we organize the evidence under each of those elements. That will let us see what documents that we have, the testimony do we have, what do we need. These are the elements that we got to prove to a judge or a jury. Where do we have gaps, right? So we break that down, we go through those elements, and then we come up with the outline. And then we have a discovery meeting to go through, okay, what are we missing here? What can we ask for? Do we have all the proof of payments? Do we have the contract? Do we have all of the elements? And that'll allow us to go into the next stage, which is the discovery request. Discovery, which is providing documents to the other side and them giving documents to us, right? Or documents, depositions, pictures, videos, all of that stuff. This is where we dive into paper request, asking the other side to provide it with us. We might also subpoena outside parties. Like if you're owed money on a public works job, we can do a public information request and request their information to see how the project progressed. But this is the stage where we're gathering evidence, requesting it from the other side. If they don't turn it over, or if they object to all our requests, we might file what's called a motion to compel to make them give us those documents, right? Then after we get all those documents in, we're going to decide if the case is right for what's called a summary judgment, right? A summary judgment means, hey, court, we have all this stuff. We can prove our case as a matter of law, right? A summary judgment won't work usually in a construction defect case because you're saying it's good work. They're saying it's bad work. We're going to have somebody decide that. A summary judgment can work in a lien foreclosure case because, like I was saying, in a lien foreclosure case, there's certain steps you have to take to have a valid lien. You can prove whether you took those steps or not. You sent the preliminary notice. You sent the secondary notice. You filed your lien timely. You sent notice of the lien. All of those, that can be proven as a matter of law. Those types of cases are perfect for a summary judgment. So we file a summary judgment and we go say, hey, judge, we followed the law. Here's all our evidence. Give us a judgment. And sometimes that works and sometimes it doesn't. So if we win a summary judgment at that point, then the other side will either pay us or we can go about collecting that judgment the same way we did a default. Right? If we can't file a summary judgment, motion for summary judgment, or the motion for summary judgment is denied, we're gonna go back and look at the evidence again, make sure that we have everything we have, because at this point we're doing trial prep, right? We're getting our exhibits in order, we're getting the testimony in order, who are the witnesses we're gonna call. At this point, what's common is a mediation to try to see if the two parties can settle on their own. So mediation. Some courts require it, but there's no final determination made at a mediation. A mediation, the parties go between a neutral mediator. He has no involvement with the case. He has no involvement with the court. He kind of hears both sides' story, and then both sides kind of go back making offers and counter offers to see if they can settle it. This is really the last point where the outcome of the case is in your control. Every successful mediation leaves with both sides leaving pissed off. They gave more than they wanted to, but it's over. right? Because if we don't settle at mediation, our next step is we're going to be preparing for trial. We're going to be getting depositions if we need them, witness statements, exhibits in order. When can we get on the trial docket, and going to trial. And trial is a very stressful thing for lawyers and for attorneys and for clients, because at that point you're going to put on your best case, but you cannot guarantee the outcome. You have no idea what the judge or jury is going to do. And even if you put on the best case and have great facts, you could still lose. Again, it could become a credibility game. Who did they like more? And so this is where, there's some cases that have to go to trial. They just won't settle. But if you can settle within a reasonable amount, it's worth doing before you get to this point. And so then after trial, you're either awarded a judgment or you lose, right? And you go lick your wounds. But if you get a judgment, then you go about collecting it, right? So just knowing this is the process, and don't be wrong, it takes a while, especially if you're in the public court system. You're looking at a year or two before you can actually get to trial. That's why sometimes arbitration is preferable. The steps are generally the same if you go to arbitration. The things about arbitration that you might consider, first off, it can be a little more expensive on the front end, but it will move faster. And an arbitrator is somebody who's familiar with the construction industry. When you go to court, you're usually in front of a judge or a jury who really know nothing about how the industry works, change orders, contracts, all that. They have no idea. They're going to go with what feels right or what looks right, not what the contract says or not how it should go. So arbitration provisions, I highly recommend, especially if you're in construction. It's faster. It might cost more on the front end, but will save you money in the long run. So guys, I hope this was helpful, kind of breaking down what litigation looks like, why you want to avoid it if you can. If you can't, we're here to help you walk through every step. Thanks.